Ready to strengthen your reading comprehension? Take a listen.
Hey there, and welcome to today's Explainer. We're getting into something incredibly fascinating today. We're cracking open the Connecticut Foreclosure Defense Tactical Playbook. What is so cool about this source material is how it completely flips the script. We're talking about moving from a passive, defensive posture straight into a high-stakes, tactical offense. It's all about holding institutions' feet to the fire and demanding strict proof. The mechanics behind this are absolutely brilliant. Let's get right into it.
So here is the game plan for today. We're going to hit 5 key strategic moves. First, the shift to offense. Second, the constitutional shield. Third, standing at commencement. Fourth, following the paper trail. And finally, number 5, executing the playbook. It's a really structured approach designed to hold large institutions to the absolute strict letter of Connecticut law.
All right, let's start with Section 1, the shift to offense, moving from passive defense to tactical abatement. Okay, so fighting foreclosure isn't about, just asking for mercy. It's actually about forcing the other side to prove they followed every single rule. To go on the offensive, we have to talk about subject matter jurisdiction. In Connecticut, if a plaintiff's mortgage assignment is somehow defective when they file the lawsuit, they completely lack what's called standing. And without standing, the court literally doesn't have the authority to hear the case. It's a non-starter. Under Connecticut Practice Book Section 1030, you can challenge this jurisdiction at any time. And if you're successful, the case has to be immediately dismissed or abated. Boom, over.
Moving right along to Section 2, the constitutional shield, protecting fixed property rights from retroactive cures.
Now, sometimes a state legislature will try to pass validating acts to kind of sweep past legal mistakes in property records under the rug, but there is a massive tactical defense against this. It's called void ab initio, which is essentially fancy Latin for void from the beginning. Let's say an old mortgage assignment was missing a required physical seal. Well, because of that missing seal, that assignment was a complete legal nullity from day one. It never legally existed. The playbook points out that a modern validating act, specifically Connecticut General Statutes Section 47-36AA, can only cure minor insubstantial defects. It absolutely cannot magically create a legal contract where one never actually existed.
And the foundation of that argument actually comes from a landmark 1930 Connecticut Supreme Court case, Prevalin v. Derby. This case establishes the vested rights doctrine. It outright declares that a validating act cannot destroy a vested right that is a property right. This is your bedrock proof. The government simply cannot retroactively take the clear property rights of person A and just hand them over to person B just to fix a bank's sloppy paperwork. You can't use a time machine to fix a bad contract.
Okay, so the constitutional theory is robust, right? But that brings us to a really massive real-world cliffhanger. How do you actually prove they didn't have the right to sue you in the first place? Like, how do you take this super high-level legal theory and execute it in a real-world chess match against a gigantic financial institution?
Well, that brings us to Section 3, standing at commencement, the strict ticking clock of jurisdiction.
Timing is quite literally everything here. In Connecticut, a plaintiff must have standing at the exact moment the action is instituted. This is known as commencement, which is usually the very second the marshal serves the complaint. So imagine this timeline. On day 1, a securitized trust closes. Fast forward to day 50 and the lawsuit is filed. But wait, what if the discovery process reveals that the physical note wasn't officially assigned to the plaintiff until day 100? Well, if the note is assigned after the suit is filed, the plaintiff completely lacked standing at commencement. It doesn't matter at all that they eventually got the note later. The case is fundamentally, fatally flawed from the jump.
Okay, Section 4, following the paper trail, physical evidence in an invisible digital world.
We live in an era of lightning-speed digital transfers, right? Everything is a click of a button. But the Uniform Commercial Code still demands strict physical realities. It's absolutely vital to distinguish between a custodian and a holder. Think of a custodian as just a giant third-party document vault. They might physically hold the paper, but they have zero legal right to sue. The holder, on the other hand, is the entity that actually possesses the negotiable instrument and holds the true legal right to enforce the debt. Courts look intensely at exactly when the piece of paper came into the plaintiff's possession to figure out if they are just a servicer, a custodian, or the actual true legal holder.
And this brings us to a very peculiar but incredibly critical legal term, the allonge.
An allonge is really just a separate piece of paper that gets attached to a note for extra endorsements when they run out of room on the original document. But here is the catch, and it's a big one. Under Connecticut UCC Section 42A-3-204, an allonge is legally invalid if it's not permanently affixed to the instrument.
So when defense attorneys demand a physical inspection of the original note, they're hunting for fatal physical flaws. Are there loose allonges? Are there missing physical seals? Are there multiple staple holes? Honestly, it's almost funny to think about, but a single extra staple hole could indicate that the allonge was attached way after the lawsuit started, which means they weren't the legal holder at commencement. That one tiny staple hole can literally halt a massive institutional lawsuit in its tracks.
All right, let's wrap this up with Section 5, executing the playbook, forcing the plaintiff to show their hand. To actually execute these maneuvers in a courtroom, the very first move is usually filing what's called a lis pendens. This is a formal notice recorded directly on the town's land records, basically stating that the title or the mortgage assignment is actively in dispute. By filing this immediately, the defendant prevents any retroactive curing of defects. You are essentially putting up a giant neon sign to the whole world and the legislature, declaring that this specific property is contested, freezing its legal status.
Next up, the defense moves for a Pritchard hearing. Instead of just sitting around waiting for a trial, you request an immediate evidentiary hearing specifically on the issue of standing. This practically stops the clock. It forces the foreclosing party to bring the original physical documents right into the courtroom. We aren't talking about vague, blurry photocopies here. It also allows you to cross-examine their witness, who is often just a robo-signer, about exactly where that physical piece of paper was on the exact day the lawsuit was filed. So the whole thing boils down to this really specific three-step abatement-first strategy. Step 1, file a motion to dismiss challenging standing before doing absolutely anything else. Step 2, assert special defenses, like that vested rights doctrine we talked about. Step 3, use discovery super aggressively to demand Bailey letters and custodial transfer logs. You are systematically forcing the other side to prove their chain of custody. And hey, if the bank tries to just submit a written affidavit claiming they own the debt, the playbook uses the hearsay shield. By referencing the case Central Mortgage Co. versus Wiedner, you can challenge these affidavits. You see, often they're signed by low-level servicer employees who have zero direct personal knowledge of the originating lender's record-keeping. If they don't have personal knowledge, that affidavit is totally inadmissible hearsay. You can't just use it.
Which leaves us with this final, really provocative thought to end today's explainer. If a massive financial institution, with all of its money and all of its resources, cannot strictly follow the basic rules of a physical, legal paper trail, do they actually possess the standing to take a person's property? It's a huge question, and it's one that completely reshapes how we view the legal battlefield of foreclosure. Thanks so much for joining me as we walk through this incredibly fascinating source material. Stay curious, and we'll see you next time.
You can still see all my diamonds home. They tried to take all my dogs.